Right, Your Honor, and I would actually request the court to really review our request. I'm not sure if you went through our responses, but
I spent my holiday reading this.
okay, thank you. So we included a lot of the documents that we have, and we're actually in the process of getting.
Excuse me.
Aaron is being given the power to
Please stop talking.
rewrite laws.
Please stop talking.
And we believe that you're actually unfairly ruling and that there's actually some unfairness going on.
And to per se defendants.
But they have not.
Excuse me, don't interrupt me again.
Hey everybody, I'm coming to you from the couch studio today. I have still problems in my own studio, still a little bit under the weather, but we're way better than I was for the past few days. Definitely getting back on track. I have some really exciting news coming up at the end of this month. I'll be coming over to London for a few days, so definitely going to be meeting up with a few people there. Anyway, I got this case from a really great YouTube channel you should check out, Lone Wolf Usul, I think is how it's pronounced. I'll link it in the description down below. But we have these very interesting folks. I was going to say young ladies, but I'm not 100% sure what the etiquette there is or whatever. But this judge is taking absolutely no nonsense. One of these individuals claims that the judge is being racist towards her, despite them both being of, well, what appears to be the same race. Also, she is a they, them, so they're being discriminated against for that, allegedly. Just because the opposing lawyer is white, it somehow means that they're being discriminated against because he knows what he's doing and they don't know what they are doing. Anyway, you're definitely going to want to stay tuned to the end of this video. It's absolutely epic, and this judge takes absolutely no nonsense.
All right, let's call file number 23-140446. Yvonne Burt, Edipong Agapan, and Anaya Amuchi versus Banyan Property Management. We have a motion for default judgment filed on behalf of the plaintiff, and we have a motion to compel discovery filed on behalf of our defendants. Could I have your appearances, please?
Nanaya,
filed on behalf.
I think somebody's video's on. But Nanaya Amuchi on behalf of the plaintiffs. And just for the record, Your Honor, we submitted 3 motions. So we also did a motion for deemed request admitted, and then also protective order, and that's included in the deemed admitted, and then the default judgment. Thank you.
Hi, my name is Davon Bird. She, her, theirs pronouns.
Thank you.
Young Adiakman, she, her pronouns.
Thank you. Counsel.
Good morning, Your Honor. Aaron Cox, P69346. I'm appearing on behalf of the defendant counter plaintiffs.
All right, let us commence with the motion for default judgment filed on behalf of our plaintiffs.
Yes, Your Honor. We filed a motion for default judgment. Prior to that, we filed a notice and a motion to deemed the request to admissions admitted due to the fact that the last time we were here, we went on record and all parties believed that the discovery was satisfied. At the time on May 2nd, the defendant had still not filed a response to our request for admissions. And so at that last hearing, we informed the court that we would be filing the motion to deem admitted. And so based on that, we are also asking the court to move in favor of default judgment according to MCR 2.603, and which says a party may be found in default for either failing to plead or answer or for improper conduct such as discovery abuses, which is also quoted in Kalamazoo Oil Corporation v. Bowerman 242 Michigan Appeals 7587 2000. And we hope that you will enter into that today.
Mr. Cox.
Your Honor, I'm going to address first the issue being raised about whether or not my client has deemed admitted responses to requests to admit. I'm not sure whether or not the court has that before it today, but I think it's appropriate to address based on the argument made by the plaintiff here. Our responses were timely served on April 19th, 2023. Those were served by first-class mail and pursuant to the court rules MCR 2.107. That service was complete the second that we put that document in the mail and sent it to the plaintiff. What the plaintiff has alleged in their motion is that because that document was not received by the court by that date, that somehow the responses just don't matter, and that's just simply not true. MCR 2.312 subsection B subsection 1 very clearly states that the matters are deemed admitted unless and until a response is, quote, served upon the requesting party within that 28-day time period. The plaintiffs in this case were certainly served with those responses in writing by mail on April the 19th. So there are no admissions that are admitted. But even if there were, Judge, MCR 2.603 is not a vehicle upon which this court can grant the default for that alleged failure. MCR 2.603 is a court rule that very clearly says that if a party does not appear or defend, that a default would be appropriate. Well, clearly, Your Honor, we have appeared, we have defended throughout the entire course of the case. And while certain segments of 2.603 would permit the court to enter defaults for like not appearing for a hearing or a trial, that's not what we have here. They're simply alleging wrongly that admissions were admitted and therefore a default is appropriate. That's not contemplated by MCR 2.603, and the court should deny the motion.
Let me hear from plaintiff. What is the day that your admissions were served?
Yes, so our first written discovery was.
No, ma'am, I'm asking for, sorry, plaintiff, I'm asking for the date of the request for admissions.
That we sent to the defendant.
Yes, counsel. Yes, plaintiff, yes.
Yes, so we sent our first written discovery on March 28th.
On March 28th.
Yes, and so.
He has 28 days from that day, right?
Right, so that was until April 25th to respond. And to this day, again, the court has not received an actual, like we haven't received it and the court has not received it. And in all of our documents, we always file a proof of service to ensure that we have the evidence before the court. There has not been any proof of filing served on the defendant's behalf. And even at the last hearing, the defendant said that they were satisfied with discovery, even at the time when we raised that still in the record, there had not been any response to our request. And to this day, there still have not been any response to our request filed before this court. Aaron Daniel.
Let me stop you right there.
Okay.
Mr. Cox?
Your Honor, we do in fact have a certificate of service on the document that was sent to them. I personally put the document in the envelope and posted it on April the 19th to the plaintiffs. It was mailed out. I did it.
The problem that we have with the motion, and of course prepared to rule on that motion, is that the court rule provides 28 days for the time to answer, and the answer is deemed to be done when it is served, that is by first-class mail or personal delivery. And in this case, there is on behalf of the defendant, answers to the interrogatory with a certificate of service inside of 28 days from which the request for admissions were issued. The motion for default judgment must therefore be denied. I don't have to get into the question of whether 603 is the appropriate rule or not, because the request for admissions were timely served.
Your Honor, where's the what is that based off of? Because we would like for the defendant to show his actual evidence of serving it. Like there's no proof of service or filing. And then even on that, the only documents we received was with his motion to compel, which included the answers that he claims he sent, but even in that, it's not notarized. And according to the court rules, it's also deemed admitted when the documents are not notarized and it was not done under oath and there was no verification for the documents that he included in his motion to compel. So the motion to compel is the first time we saw any form of answer, but even then there's no notary, it's not notarized. And so that is actually a violation of the statute and also provides for the request to be deemed as admitted.
Mr. Cox?
Your Honor, there is no requirement for responses to requests to admit to be notarized. There is a requirement for interrogatories to be sworn to, not notarized anymore after the changes to the discovery court rules. The interrogatory responses that were attached to our response and that were served on the plaintiff, in fact, were verified by Erica White, the authorized signer on behalf of the defendant.
Okay, The court, I'm convinced Mr. Cox's interpretation is appropriate. I mean, it's what the court rule says. Your motion for default judgment must be denied. Now, is there anything you wanted to move forward? Anything else on behalf of the plaintiffs?
Your Honor, so just to clarify, what is the court basing the service on?
I find that the request for admissions, which are the basis for your motion for default judgment, were timely answered.
When were they answered?
Excuse me.
Okay.
I find that they were timely answered, and therefore there's no basis to deem them admitted. There being no basis to deem them admitted, there is no justification for a default judgment. Thank you. I've ruled. You have absolute right to appeal my decision, but that is my rule. Is there anything else you want to bring to the court's attention today?
Yes, in there, we also had a motion for a protective order to prevent a defendant from harassing us, undue burden. He has sent a number of motions to compels, even though if you look at our responses to the request admission is thoroughly answered. And we've gone through each of the request admissions and the interrogatories and have thoroughly answered it. But this is the second time I think that the defendant has requested a motion to compel for things that we've already answered thoroughly. And also, Your Honor, we would ask that if the defendant, because again, we have not received the answers to our request to admission. So if the defendant can either file that in the court or resend it to us, like there's no proof of filing or service only based on what he says. There's no actual documentation of that. And so we haven't actually received it. So we're also asking the court to request that he do that so that we have
let me stop right here. I have made my ruling in regard to the request for admissions. If you disagree with it, you may file an appeal. I would suggest you read the pleadings filed on behalf of Mr. Cox, which included, among other things, his answers to the request and a certificate of service of the same answers. Now, Mr. Cox, you had a motion concerning discovery, and they have filed responses. Are you satisfied with those responses?
I am not, Your Honor. So this is actually the second time that we've had to file a motion to compel. We filed our first motion on or about April the 19th. And I think about a day before we were scheduled to argue that motion, they did in fact submit responses. The first motion was premised solely upon the absence of the response at all. Now that we've had an opportunity to review those responses, we've filed the motion that's before the court today, asking the court to compel further, more specific responses with respect to the requests and their interrogatories. And as I've laid out in my motion and briefly summarized, we asked 11 document production requests, including documents supporting their claims for damages, and we got nothing. Literally not a single document was produced. We asked a number of interrogatories that asked for details about what witnesses they have or are aware of, what inspections they performed, what representations they alleged that the defendant had made, and damages that they alleged to have incurred. And they didn't give us any of those responses. And while they did give some very thorough responses to a couple of the interrogatories, they were not responsive to the other requests. And they didn't place a proper objection on those responses at all. So we'd ask the court to compel them to provide full and complete responses to those document production requests and interrogatories within a reasonable period of time.
Were any documents provided in response to the notice for production of documents?
Yes, because the majority of the documents that the defendant requested, we have already provided it in our original pleading, which included.
That's not the way the rule works. The way the rule works is that if they ask for production of specific things, you are supposed to provide those things in response to the notice for production of documents.
We did provide some document. We provided the documents that we had, and even in our answers, we said we provided all the documents that we have in our possession at this time, and we will make it available to the court on a rolling basis. That's what we responded to. We were not we were not fighting the discovery. And then we also named that some of the documents that are requested are already in the defendant's possession, and that it would be unduly to reprint the things that they already have.
Okay,
and
well, let's stop right here in that regard. This is a lawsuit that you brought. They are empowered under the court rules to defend the lawsuits using, among other things, request for production of documents, request for admissions and interrogatories. And I don't understand the argument that something that you claim that a document that's going to be used at your trial is too burdensome for them, for you to produce.
Oh, well, that's because
what
he
I'm-
asked for a very broad, he asked for any and all documents from the whole last 5 years. And so we said we already supplied the documents that are relevant to the last
All
2
right, this
years.
is
And that
what
would
I'm,
take time for us to find those documents. We're pro se documents. So we have provided a lot of the documents he requested, we provided it. You know, if you actually look at their request.
all right, let's stop right here.
Mhm.
Mr. Cox, you will draft an order adjourning your motion to compel until June 27th at 11 o'clock. You will draft another order denying the plaintiff's motion for default judgment for the reasons set forth on the record. I am going to give you an opportunity, plaintiffs, to supplement your production of documents, interrogatories, should you choose to do so. If you don't choose to do so, then I'll move forward. But you've told me that you have not provided a number of documents that he requested in his notice for production of documents.
Right, we've provided some of them, and the other ones we said we would provide it when they become available.
But
That's
they haven't been provided. That's the point I'm making.
right, yeah. So, but
So
I'm
here's
just.
what's
that
let me tell you how,
responded properly. We responded.
tell you how
properly
this is going to happen.
Mhm.
You're not understanding me. You brought the lawsuit. You have an absolute right to do that, but they have a right to defend. They have a right to use the tools under the court rules, and the court rules provide they can say, show me the documents. So what I'm going to do is I'm going to adjourn to give you an opportunity to provide the documents, supplement your responses. Because when we come together again on this, if you haven't provided the documents, I'm going to have to move in another direction here.
Right, Your Honor, and I would actually request the court to really review our request. I'm not sure if you went through our responses, but
I spent my holiday reading this.
Okay, thank you. So we included a lot of the documents that we have, and we're actually in the process of getting inspections. We're in the process of getting a lot of the documents that they requested. So we're not trying to fight or combat the discovery. In fact, I think it's the defendant who's trying to combat the discovery because they actually haven't really responded or done anything. So
okay,
I appreciate your time for reviewing our documents.
That's what the taxpayers pay me for. So, Mr. Cox, do you understand the court's orders?
I do, Your Honor.
2 orders. Now, the next time we're together, given that discovery is closed, and given that there's been an opportunity to supplement any, how to say this, perhaps omitted, unintentionally documents, I'm going to be very, very forward and strict on this. We're either going to have compliance or we're going to have sanctions. That's the way it's going to be. Now, what I would urge you all to do, and again, I can't order you to do anything. I would urge you to consider. Yeah, let me ask one more question. What has happened on the landlord-tenant case? All I need to know is, has it been concluded or not?
It has been concluded, Your Honor.
Okay.
It's being appealed currently. So there's actually
there's been an order.
There's a bond placed on the landlord tenant pending the appeal.
What was the order of the court? Possession for the defendant?
Yes, Judge.
All right. Okay, so that matter is closed out.
There's a bond pending the appeal, so it's actually being appealed in the.
It's really that was just an information for me because as I indicated, as I earlier declined to consolidate the cases, the court has a landlord-tenant division, and in that we bifurcate frequently 2 things: possession, which is all as I understand it was decided in the landlord-tenant matter, and any claim for money damages, which is where we are on this file. So we will be together next June 27th at 11 o'clock. I'll be looking forward, Mr. Cox, to your orders.
I'll have them over.
Accomplished today.
Thank you very much, Your Honor.
Your Honor, I do have something to say, if that's okay, please. Just a
Identify
few
yourself,
minutes.
please, and please say what you want to say.
Yes, my name is Young.
Okay,
And
please say what you want to say.
thank you. Yeah, so just to summarize something, this is not to really change your opinion because you have definitely shared your opinion and we've heard you. But just to say some things for the record, as the court person is taking the court transcript. So as of today, May 30th, we have provided overwhelming amount of evidence to show retaliation and harm and harassment, right? We have court registers, proof of services. We have pictures. Plaintiff has even, defendants have left us to our proofs even. We've showed ample evidence, different leases. We have shown pictures of the home. We have shown email correspondence with the defendants and us. We have shown many evidence. The only evidence that Aaron has submitted to us as of May 30th to us in our home and even to the court records is the 2019 to 2020 lease, or sorry, 2021 to 2022 lease. That is the only evidence Aaron has ever submitted from the
All right, let's
beginning
stop right here.
to this
This
end.
is Scott,
And
excuse me.
Aaron is being
Excuse
given
me.
the power to
Stop, please stop talking.
rewrite laws.
Please stop talking. I would like to avoid muting you. You will refer to him as Attorney Cox. or Mr.
Attorney
Cox.
Cox has also harassed us, right? That's why we had the motion for protective order, because he continues to harass us. He continues to oppress us in violation of court rules when we continue to supply ample evidence. The evidence we have given to him surpasses the evidence he has given to us or the court. And so just wanting that to go on the record, right? Because yes, we have multiple court cases and multiple investigations because we are being harmed
Don't fade
and
away.
oppressed.
Keep talking close to the mic. You're fading in and out because you're moving away from the mic.
Well, I hope the court recorder was able to write those out in the transcripts.
Now, just so you know, there is no court reporter. This is a jazz recording. It is a multi-track recording, which every time one person speaks, that put on that one single track. So there's a track for you, there's a track for Mr. Cox, there's a track for each of the plaintiffs. So if you decide you want a transcript, there won't be any of the blurring that you frequently get with court reporters when several people try to speak at once. We're on the JAV system and have been all the time. Anything else anyone else want to say?
It's still being recorded and we'll try to get the transcript, but we'll also still argue it in the appeal for sure. Because definitely we have ample evidence. We have supplied to Aaron Cox and proof of that evidence, and he has supplied no evidence whatsoever and also has answered to our stuff late. And that is in the receipts that we have provided to you over and over again, and that we have, and that we will continue to produce, right?
All right. Your appeal is not of my decision, because now you have an absolute right to appeal any decision I make, including the two decisions I've made today. But your appeal is as to whatever it is that happened or did not happen in the landlord-tenant division. All right, we'll talk to everybody again, June 27th.
We just want to, one more thing.
Please.
Yes, so, in the pattern of what we've been discussing around the unfairness and the inequality and the injustice of this court, just want to reiterate that my co-plaintiff said that the only thing that Attorney Cox has ever supplied has been a lease. And we believe that you're actually unfairly ruling and that there's actually some unfairness going on. There's a lot of rules that we have mentioned today and mentioned in our briefs that continue to be disregarded before this court. And we just want to, again, put that on record that we are being treated unfairly. We are pro se plaintiffs. Aaron Daniel Cox is being paid hundreds of dollars an hour to represent defendants and continues to, and has a whole law firm of people who are researching, who are supplying things, and he's never to this day filed a proof of filing. It's required by this law, by the court, to file a proof of filing, but you're basing things based on his words but he will not file a proof of filing before this court. Everything that we have filed and gone before this court and filed a proof of filing so that we can say, actually, it was served on this day. We're not just depending on our name and our say as an attorney or as a man or as a white person. It's unjust.
All right, I understand your objections. Again, you have an absolute right to appeal any decision that I make. And I would further point out for the court rules that the court rules apply equally to plaintiffs and to per se defendants.
But they have not.
So, excuse me, don't interrupt me again. I would further point out that at least on one occasion, you told me that you were an attorney licensed to practice law in the state of California.
In DC, I was once licensed in California, but my first introduction to the state of Michigan is facing an eviction. So I just got here. Now I'm having to.
All right, thank you.
Eviction.
All right,
It's very unjust. So I'm studying.
I understand you. And again, you have an absolute right to appeal any decision that I make.
Absolutely, and we have absolute right also
to interrupt me again.
Unjust
Right.
in this court.
I'm going to mute you now because I'm tired of being interrupted. If you are, as you say, an attorney licensed to practice anywhere, at minimum, you ought to have some understanding of courtroom decorum. So we will talk to you all again.
And I understand justice too.
Please do not interrupt me again.
You are using two different.
I'm going to mute you, ma'am. Thank you. We are on the
I'm not a ma'am.
We June 27th at 11 o'clock. Thank you all for coming in. Go off the record.
Thank you, Your Honor.
Read the court rules.
You're applying different court rules. You're applying different rules to Attorney Cox. There's no proof of filing. There's no proof of filing. There's no notary. There's no proof of filing. He hasn't done a lot of things, but y'all keep having side conversations and applying different rules.
Ma'am, we have.
I'm not a ma'am. I'm not a ma'am. That's part of the discrimination we're facing.
Plaintiff, we have.
You're applying different rules to Attorney Cox than you are to us. He has never filed a proof of filing before this court. He has no evidence about anything he's done. It's just his word.
I'm not going to continue this.
Well, that was a bit of a clusterfuck, as we say. Yeah, that was quite something. You know, when in doubt, pull out the race card, blame sexual orientation, blame gender, whatever the case may be. You know, whatever you do, don't blame your own negligence. Anyway, folks, thank you so much for joining me. I really hope you enjoyed this. If you do, make sure and hit that like button, comment, subscribe, all that good stuff. And definitely check out Lone Wolf channel. I will link that again down in the description. Sláinte.